So welcome everyone who's joining us today, and thanks for spending your lunchtime with us. I think I'm going to get started now because we only have 1 hour. So this webinar is brought to you as part of ClientEarth's joint project with Justice and Environment on the topic of access to justice for a greener Europe. It's funded by the EU's LIFE programme. I'm Friel, and I'll deliver this webinar with my colleague Sebastian Bechtel. We're both lawyers in ClientEarth's Environmental Democracy programme. So, as I said, we only have 1 hour, and in that time we aim to give you a broad overview of the public's right to request access to environmental information and its right to challenge public authorities when they refuse access. So during the webinar, you can send written questions to us, and we'll try to answer as many as we can following each of our presentations. There are quite a lot of participants, so we probably we don't have time to use to take questions orally. But because this is quite a broad overview and we don't have time to go into a lot of detail on some aspects, we plan to hold more webinars on this topic in the coming months. And so at the end of the session, we'll ask for your input to help us decide exactly how we'll do that. So stay tuned to the very end. Right, so first things first, before we can challenge public authorities for refusing access to environmental information, we have to request it first. So just now I'm going to give you a very quick overview of that first stage of the procedure before I hand over Sebastian to guide you through the questions of exactly what arguments we can bring to challenge refusals. So I'm going to cover the applicable legal provisions at both EU level, that's to say when requesting environmental information from EU institutions, as well as at the level of member state public authorities. In some cases, the applicable laws are almost identical, and in other areas there are some notable differences. So I'll point those differences out as they arise. And we will then look at the concept of environmental information before discussing why it can be a good idea to make a formal request for access. And finally, I'll take a brief look at how to submit a request and the options that are open to us when that request is denied. So, start with the legal provisions. So, in the area of environmental information, the EU and all of its member states have signed and ratified the Aarhus Convention, which is a UN treaty which guarantees the public the right to access environmental information and to challenge refusals. So this international law applies every bit to the EU institutions as it does to public authorities in all of the member states. So when it comes to requesting information from EU institutions, the Aarhus Convention is implemented through 2 EU regulations. So the General Transparency Regulation, which actually gives effect to the Article 10 in the Treaty on European Union, and Article 15 in the TFEU, which give a general right to access the documents held by EU institutions. So that General Transparency Regulation really contains all of the procedure and all of the exceptions, but it has to be read with another regulation when we talk about environmental information, which applies specific provisions of the Aarhus Convention. And that can sometimes make quite a difference. At member state level, the EU has implemented the Aarhus Convention in all of the member states through Directive 2003-4, which I'll refer to as the Aarhus Directive. So as opposed to general freedom of information laws, which have not been harmonised at EU level, there are minimum EU standards that apply to all national public authorities regarding environmental information. So that's really important to note, because sometimes not all national public authorities are aware of that, and they will try to treat your application just under the general freedom of information laws that apply, and often they're not exactly the same. So obviously, because it's a directive, this leaves some discretion to the member states in its implementation. So you must always check the applicable national implementing legislation when requesting information within a member state. That's really because some of the provisions do vary. So how does the public access environmental information under the Aarhus Convention? So these legal provisions envision two means of access. The first is when an individual, either a natural or a legal individual, submits a written request to access specific information and then receives a reply addressed directly to them from the public authority. The other means is when public authorities themselves proactively publish the information they hold. So the Aarhus Convention imposes obligations in both of these areas, but today we're really going to focus on the first. So a request can be submitted by any natural or legal person without discrimination as to citizenship or place of residence or the centre of economic activities. And a request can be submitted to any public authority. So at EU level, that's quite easy. It's any EU institution or body, so that's the agencies and authorities that exist. And at member state level, the term public authority is defined very broadly in the Aarhus Convention. So it's not defined according to the legal status of the entity. So it doesn't only apply to kind of public authorities in the traditional sense in that they are state departments or authorities. It also covers any entity that carries out a public administrative function or performs environmental services under the control of the state. So in this way, it can cover both semi-public entities and indeed private organisations, as long as they fulfil the conditions. Moving on, what is environmental information? So again, this term has a very broad definition in the Aarhus Convention, and it's been faithfully implemented throughout the EU. So it covers not only the state of the elements of the environment, like air, water, soil, land, etc. It also covers the factors that affect or are likely to affect the elements of the environment. So that's substances, noise, discharges, emissions, etc. And it covers all of the measures that can affect the environment, like legislation, plans and programs, and specific decisions. It also covers these other things that are listed here. So, for example, reports on the implementation of environmental legislation, economic analysis using the framework of deciding on measures that affect the environment, and the state of human health and safety and the conditions of human life. So many public authorities are not aware of the breadth of this definition, and sometimes it's often necessary to bring their attention to that. For example, we sometimes have some trouble convincing the European Commission that fisheries information, for example, is environmental information. So I'm briefly going to touch upon this very important subcategory of environmental information on emissions into the environment. That's because the public enjoys stronger rights of access to this information because, by its nature, emissions enter into the public domain and affect us all. Sebastian will explain more about this later, but just now I just want to suffice to note that the definition has been given is very wide according to the EU case law. It obviously includes information on actual emissions from industrial plants, etc. But recently it's been confirmed that it also includes information on actual and foreseeable emissions from any substance that is intended to be released into the environment under the normal conditions of its use. So this can include, of course, pesticides and GMOs, etc. So it seems like an obvious question, but I quickly want to run through the main reasons why we might want to submit an official request for access to environmental information. So obviously it's usually to get access to information that's not otherwise in the public domain. And this can be so that we can participate effectively in a decision-making process. So understanding the evidence base for a decision or the positions being defended by decision makers can really help us to make timely and strategic interventions to protect the environment. And obviously requesting this information, even after a decision-making process has ended, is also vital to holding officials and representatives to account for the decisions they've already made. So it can also be a useful tool for having confirmation that a specific piece of information exists or not, if you just simply don't know. And it also can be a good way of knowing if public officials are discharging their kind of statutory duties correctly, and to put pressure on them to do so, to know that they are being observed by the public in that respect. And obviously, when we make requests for access to environmental information, we often have the broader and more long-term impact in mind. So we really gradually aim to change both the attitudes and behaviour of public officials to transparency, so that it becomes the norm rather than the exception. And also in requesting information, and importantly in challenging unlawful refusals, it can have the wider impact of creating useful precedent that other individuals, environmental organisations can rely on. So in that respect, we all support each other and help each other in our work. So, and finally, when more and more information is released upon request, we hope that that kind of drives public authorities to see the benefit of actively publishing more and more information, so that we don't necessarily have to make requests every time. So I have included a couple of slides here that kind of lay out how to make that initial request for environmental information, and that show what the kind of duties of the public authorities are in that respect and at that stage of the procedure. I don't think we have time to go into these in very much detail just now. So I've done this for both the member state level and on the EU level. There's just two things that I really want to point out. And that's while the Aarhus Convention and the implementing legislation lay down minimum time delays for the public authorities to reply, and then for the requester to go back and submit an appeal, these deadlines really do vary among the member states and the EU institutions, and it's really important to check the national implementing legislation before you make a request, so that you have them just right. It's also important to note that the Convention does allow public authorities to charge a reasonable amount for supplying information. I think that's back on the slide, yeah. And again, these charges really vary significantly, not only among the member states, but within the member states themselves. So you should really check this out beforehand. We still see a good bit of non-compliance on this point, with some public authorities that continue to apply really very dissuasive charges for the supply of information. Happily, at EU level, they don't charge at all for the supply of information, so that's good to keep in mind. Right, so finally, you've requested your environmental information and you've received a refusal. So where do you turn next? Who do you complain to? So the first thing to note is that that information really should be contained in the refusal decision itself. So you shouldn't have to look for that information anywhere else. But if it's not contained there and you don't know the answer, really be sure to inquire to the public authority. So obviously this question really varies depending on the member state that you're in, what public authority you've requested to, etc., and whether you're on, kind of requesting on the EU or the national level. So we're going to have a little. Oh no, that's it. We're going to have a look on the EU level first. So when an EU institution refuses a request, the first thing you have to do is to draft what's known as a confirmatory application. So that's an appeal, but to the same institution that refused you. So the same institution has to then reconsider whether to give you the information or not. So you've got 15 working days to do this application, and it really should contain all of the reasons why you think the decision is wrong. You should be as expansive as possible on this, because if you do go on to challenge this at the next stage in court, you may not be able to bring new arguments at that stage. So really kind of take a broad approach to your confirmatory application. So the institution should then send you its reply to that confirmatory application within 15 working days. And if you're refused again, you have two mutually exclusive options for further action. So I really want to stress that you cannot do one after the other. You have to choose at that point which way you go, either the judicial route or to the ombudsman. So if you go the judicial route, that involves applying to the General Court to annul the refusal decision. and there you'll have to be represented by a lawyer in the court. So you only have 2 months to do this, so it's a really quite a short time frame. And if it's successful, the reality is that means that you have to go back really and request the information again, and the institution should take that decision, and when it does so, apply the judgment of the court. So hopefully it should mean that you should, at this stage, get the information. So if your court application, though, is unsuccessful, there is one further right of appeal to the highest court of the EU, the Court of Justice. So the second option is to go to the EU Ombudsman. So this is a non-judicial avenue, which has obviously its pros and its cons. The deadline to bring a complaint is 2 years, so that's quite a nice long time frame. And you don't need to be represented by a lawyer. It's a lot less formal. So on the negative side, the findings, though, of the Ombudsman are not legally binding on the institution, and therefore we really rely on the institution to take up the recommendations in good faith, which sometimes isn't always the case. To the member state, obviously this is where we have real divergence among the member states. So I'm just going to I'm going to talk to you very much on a general level about that. So in practice, most member states have 2 instances of appeal. So the first is usually an administrative appeal. So it's either an appeal to the same institution or to another administrative authority. And then beyond this, the convention requires there to be a further right of appeal to an institution, which is usually a court or another maybe semi-judicial body, but it has to be independent and impartial and have the ability to take binding decisions and provide for effective remedies. So I have put some examples of just a few member states on this slide. Unfortunately, we couldn't cover all of the member states, but that information is widely available at the either from national authorities or, if not, even from the European Commission's website. And we can, of course, help you find it if you need that. So I'm now going to hand over to my colleague Sebastian, who will take you through the main arguments you can raise when you challenge refusals. Very quickly.
Yes. Hello, everyone. So I will be taking the second part and just walk you a little bit through how to challenge refusal. So if you receive a refusal, what you can argue, and just give you a little bit of an idea what the exceptions from disclosure are. So when an authority can validly withhold information and refer you to some relevant decisions, some relevant judgments of the Court of Justice, just that you can rely on as well if you file an appeal or if you challenge a refusal, both on EU and on national level. So first of all, what is important to understand, of course, is there is valid exceptions that are included in the legislation. So this is first of all on EU level in the 2 regulations that Anne has already referred you to, and regulations 1049 and 1367, Articles 4 and 6. And this lists the exemptions from disclosure that the EU institutions may rely on, and very similarly on member state level, those are covered by Article 4 of Directive 2003/4, and they are largely the same. What is important to understand is that this is a closed list of exceptions. So if it is not covered by one of the exceptions, the information should be disclosed. And the other important point is that the Court of Justice has established that its case law applies equally to the directive and the regulation, so that these should be applied in the same manner. So you should be able to rely on the case law that I'm referring you to in this presentation also when you're challenging a national refusal. So what are the main grounds on which information is denied and on which you can challenge a refusal that you may receive? So first of all, a very common thing that might happen is that there's just simply a lack of reply within the timeline. So I has already referred you to the fact that these differ largely between member states. So you need to check what these are. And then the authority might simply just not reply to you in that time. and this constitutes an implicit refusal. So on EU law, and this should also be the case under member state level, there might be some member states, such as Austria, where you have to receive a specific reply. But in general, this is an implicit refusal that you can challenge. And so you can rely on your appeal possibilities that Anne explained. However, the fact that the authority doesn't reply doesn't in itself mean that you will receive the information. It just means that you are then have the possibility to rely on your possibilities to challenge that decision, not that the information will necessarily be disclosed in the end. Second of all, there may be a mischaracterization of your scope of request. That may be another ground in which you can challenge a refusal. So you make a request, you set out exactly what you would like to get access to, but then the authority replies with only part of that, replies to part of that question essentially, or just answers something else. And then that might just happen by mistake, or it may also be a tactic to simply divert you from accessing some of the information that the authority might not be willing to disclose. So be very sure when you formulate your request that it's very targeted, and then also to check once you receive a reply, once you receive a refusal, whether the authority has indeed stayed within the bounds of your request. If it has not, it is again an implicit refusal to that part of information that you've requested, but where you've just not received a specific reply to. Thirdly, there may be a failure by the public authority to characterize some of the information that you have requested as environmental information. And now, as Anne has said in the beginning, there's a very wide definition of environmental information, but nonetheless, authorities might say that certain information is not environmental information and therefore apply a different legal regime. So on EU level, that would mean that they would simply apply only one of the two regulations, Regulation 1049/2001. And on member state level, it may mean as well that you are getting into a different legal regime where access is not as favorable to you. So you always would want to have your information request treated as relating to environmental information. And that is again something that you would want to insist on in reply to a refusal if you're challenging a refusal to disclose information. Fourthly, there may be a failure to consider whether it's possible to partially disclose a part of a document, part of the information that you've requested. So what we see quite frequently is that we request certain information and we receive a reply saying this 500 pages report is in its entirety covered by this exception. But that's very unlikely to be the case. There's often some information that will not be covered by that. And there's therefore very important to insist on this, that there's partial reductions being undertaken by the authority. This is a clear legal obligation on both EU level and on national level. So that's again an important basis to challenge a refusal. So fifthly, and this is the first one of the exceptions that I will afterwards go into some more detail on, is that there may be a failure to rely on exception completely or to sufficiently justify application of an exception. And there's a certain threshold to be met there by the authorities. Then there may be an error in law in relying on a specific exception, so that essentially just means that there's a misinterpretation of the exception, or that the authority tends to rely on a specific exception that doesn't apply in a specific case. Again, I will say more about some of the specific exceptions in just a bit. And then there's an obligation to weigh the public interest in disclosure against the exception. So I will say a little bit more about that as well. So if authorities completely fail to do that and mention that, again, that's a basis to challenge a decision. And finally, there may be a failure to characterize some of the information as relating to emissions into the environment. So as Anne has already told you, there's a stronger obligation to disclose information related to emissions. Some of the exceptions don't apply. We'll explain that later. So that's another important point. So I will just speak a little bit more about these last four of these points. just now in some more detail. First of all, the obligation to provide reasons. So, as I already mentioned, of course, if there's no reasons given whatsoever and the information is just refused, that's a failure to comply with the applicable legislation. But it may also just be that it's not sufficiently justified. It's not clear to why a specific exception would apply in a specific case. And so the Court of Justice has made very clear in this case that in this regard that the burden of proof is with the authority that makes the refusal, and in particular that authority must explain how giving access to a document, to information, could specifically and actually undermine the interest that they're relying on. And the risk of that happening, the risk of that negative effect materializing, must be reasonably foreseeable and not purely hypothetical. This establishes quite a strong burden of proof that is regularly not met by the authorities. So it's a thing that we argue quite frequently in reply to refusals. There is, however, an exception where the burden of proof in fact shifts, at least on EU level. So this is an invention on EU level that the Commission has come up with and has been unfortunately confirmed by the Court of Justice in a number of cases. This is a presumption of non-disclosure, presumption of confidentiality. This means that there's an assumption that this document should be confidential, which essentially shifts the burden of proof, saying, well, you have to specifically show why it shouldn't be confidential in this case. It's not an obligation on the authorities to rely on it, but they will frequently do so. I've listed here the cases in which the court has so far accepted that there's a presumption of confidentiality. We'll not go through them in any detail, but they're on the slide. You can look at them later. What I will get back to in some more detail is documents relating to infringement procedures, because that's quite a case that comes up quite frequently. So the next issue, of course, is if an authority attempts to rely on a specific exemption, but commits an error in law of doing so, just doesn't adequately apply the exception. So first of all, there is some general applications that the authority needs to meet when it relies on exceptions. First of all the exceptions are to be interpreted narrowly. So it cannot simply make a general application of it, saying this generally relates to this interest, so this whole document is to be withheld. That's important, and important to remind the authorities of. And then on EU level, there's a particular aspect that the court has specifically recognized, that there's greater need for transparency in the legislative procedures. That is based on the treaty directly, on Article 10, paragraph 3. And the court has said that this puts a specific obligation, a particularly strong obligation, on the authorities to not withhold information if it is relevant to a legislative procedure. So in particular, in the adoption of a directive or a regulation that will be generally applicable throughout the EU. So what are the specific exceptions? First of all, there's an exception related to public security, defense, international relations. This is a rather strong exception because, of course, related to security matters, and the court has confirmed that authorities have a rather wide discretion in relying on this exception, but they must nonetheless still show that there's a specific and actual effect on a protected interest. So an area where this is applied and where there's been some litigation on it is the negotiation of trade agreements by the European Commission. And essentially the court has applied in a way that it said if the information, the document reveals strategic objectives in the negotiations while these are ongoing, its information can be validly withheld. But if that's not the case, it should be disclosed. And of course, there will also be a change of situation once the negotiations are closed. We have, in fact, just filed a conformity application in a similar situation on that. Secondly, there's an exception protecting personal data. So information that relates to a private person, his name, his address, and so on. And there's again a particularly high threshold for disclosing that information. So in this particular situation, it must be specifically established why disclosure of personal data is necessary. That derives from the data protection regulation that are applicable in the EU. So it's another piece of legislation to be taken into account in these cases. And even if that's the case, one must always still weigh the interest of the data subject against other interests, so other public interests in particular. Mostly this is not up to much debate because it might just be specific names and so on that are not so relevant when you seek environmental information, but there's other situations, one being a case that ClientEarth actually had in front of the court, where it concerned the names of external scientific experts that prepared specific advice to the European Food Safety Authority. And that was initially refused by the Court of Justice, overruled that in the end, saying that in this case, one couldn't rely on the protection that this was personal data. Thirdly, there is an exception related to court proceedings, and legal advice. And it's a bit differently formulated between the EU and the member states, between the regulation and the directive. Some examples for where this is applied is opinions of the EU legal service. These are, of course, often interesting to know what are the legal considerations applicable to the drafting of legislation and so on. And so the court has addressed this in a number of cases and has said, generally, these should be disclosed as well, unless there's a specific risk that relates to undermining that advice. It's, of course, not a very clear standard. There's some case law that I'm referring to you here. And for a national example, there's now a pending case in front of the Court of Justice, a referral from Ireland concerning whether court pleadings should be made accessible after judgment has been rendered. So we will see what the court says on this particular point soon. Then turning to some of the exceptions that are more frequently or very frequently used and where there's more of a debate. So where you can argue more whether they're applicable or not. First of all, information related to commercial and industrial information is protected if this is necessary to protect legitimate economic interests, and this also protects intellectual property. So with regard to commercial and industrial information, this would be in particular information on commercial strategies, sales figures, market shares, customer relations. Those are examples that the court has mentioned. But we see that this exception is relied on quite broadly often, and this is, of course, not in line with the regulation. As we said at the beginning, the exceptions are to be interpreted narrowly, and there's some relevant court cases as well on this. So the court has held, first of all, that it cannot be sufficient that information simply characterize all information related concerning a company as being covered by these exceptions, all information concerning its business relations, because of course all information on a company will always be somewhat relevant to a competitor and so on, but this is insufficient. And it has also established a certain threshold, meaning that the disclosure must seriously undermine the commercial interests of a legal person. Again, there are some relevant case references for you there as well that you can rely on. Turning to the next exception, is an exception for documents that have been, or information that has been drawn up for internal use, so containing opinions for internal use. If disclosure of that information would seriously undermine the decision-making procedure. So this is something that is being relied on quite frequently by the European Commission, but as well is an exception where the court has been quite strict and imposed stringent requirements. And so some of the things the court has said I have included in this presentation. First of all, that a mere reference to a risk of negative repercussions linked to giving access to a specific document is insufficient. And also the mere possibility that interested parties may influence the procedure does not suffice. And this is very important because very often the authority might want to argue, well, we need our space to think, we need to be able to exchange our views freely, but in fact, and therefore, if we would disclose it, we would be contacted by NGOs, by industry, and so on. And the court has said this is insufficient and made it even more clear in some other cases where the institution had particularly argued that it would undermine their credibility if information would be disclosed, because it shows different views within the authorities and so on. And the court has said, no, this is the opposite is the case. Transparency ensures credibility, and transparency demonstrates that the institution is acting independently, that the institution acts in the general interest only, and instead, if information is being withheld, this goes against the credibility of the institution. And so this is some very strong statements that you can rely on. Also in one, in particular, in a case that we had recently concerning the disclosure of draft impact assessments and potentially draft stuff too. And that should be disclosed now prior to publication of legislative proposal. So have a look at that. It's very useful stuff. Then we have two more exceptions that I would like to cover today. One is only applicable on EU level and relates to inspections, investigations, and audits. As I mentioned before, this is the one that's being relied on in relation to infringement proceedings and is very problematic because essentially it's not only documents related to infringement proceedings, which already would be very interesting to have to see what the Commission is arguing. Actually spoken yesterday to somebody from the Commission who agreed with me on that point, but she doesn't seem to represent the majority opinion in her institution. But it also extends to all kinds of documents that relate to the preparation of an infringement case. And that essentially means that the Commission has expanded this to mean that all information that relates to a violation by a member state of EU law can no longer be disclosed because it could amount to an infringement procedure at one point. That's very problematic, and because of the presumption of confidentiality, it's a really high threshold to overcome and get access to any of these documents. And for this exception doesn't apply in the member states, but there's another exception that applies there that doesn't apply on EU level, and it relates to the confidentiality of proceedings and to unfinished documents. So on the one hand, this is if there's a document that's in the course of completion, it's unfinished, it can be withheld on that basis. And on the other hand, confidentiality of proceedings, if that is provided by law. And so the question, of course, in that regard is what is material in the course of completion and what are proceedings? There's not so much guidance on that from the court yet. Therefore, I'm referring here to a finding of the AS Convention Compliance Committee, who made very clear that material in the course of completion means, and that might appear obvious, but it's maybe not, that it relates to document that's not finished, and specific documentation or information doesn't relate to the decision-making procedure. There's a clear distinction. It cannot be simply that the decision-making procedure on a document is ongoing. It's whether a specific document is still in draft form and so on. And even then, it doesn't mean, of course, it can never be disclosed, but then at least this exception might be applicable. So we've seen that being misapplied in Switzerland, in the UK, and Romania, that authorities have said essentially this is material in the course of completion because our decision-making procedure is ongoing, and that's not how this exception is supposed to work. And then confidentiality of proceedings. So what are proceedings? So again, here a statement from the IAS Convention Compliance Committee. Proceedings must be concrete events, such as meetings or conferences, and they don't encompass all actions, and there must be some kind of operational and internal procedure. So that's something can be useful to refer to in case the authorities attempt to apply a too broad and sweeping interpretation of what a proceeding is, and also some indication from the Court of Justice stating that it cannot be the entire administrative procedure, at the end of which the authorities might hold their proceedings. So everything that's before that wouldn't fall under the exceptions as well. That's in some regard. So those are the specific exceptions that I wanted to talk to you today, because they're the ones that are the most frequently used. But there's two other aspects to still cover and to consider. On the one hand, there's the public interest in disclosure. So the authorities must always weigh the public interest in disclosure and whether the information relates to emissions into the environment against withholding the information. And if the authority doesn't show any kind of indication of it having done so, that's a base to challenge it too. It's of course difficult to establish that it has done this weighing exercise in a wrong way. Substantively, there's also not a very good indication from the court on this. One would assume that it would, if there's an immediate threat to public health or the environment, that this should apply, that this might tip the balance in favor of disclosure. And there's another aspect here that I won't go into detail. This is a bit complicated on the EU level. There's a difference between taking into account public interest and there's overriding public interest for some exceptions. But then this would go into too complicated terrain for now. But in any event, this is an obligation to always take the public interest into account as long as the information is environmental information. And finally, information on emissions. And we have already mentioned that as well, and as explained in the beginning, that what kind of information that is. And there are some exceptions to which cannot be applied at all to information on emissions into the environment. And so these are differ on EU level and member state level. Made the list here. Surprisingly different. And but for the other ones that are not on this list, it still needs to be taken into account. So it still needs to be part of the weighing exercise that I just mentioned on the previous slide. But for these specific exceptions, they may not be applied at all for information relating to emissions. So this is, of course, a very strong argument if you can establish that. So so this concludes my part of the presentation. We already have, I think, some questions, so we will turn to them just now. And otherwise, of course, feel free to just now start typing, asking us whatever you want, and we'll spend the last 50 minutes of the presentation doing that. So the only question we have so far is whether we will share the presentation. So yes, we will do that. There will be a recording of this as well that we will try to make available. So we will send that to you for sure, and I think this will also be made available online. And we also share the presentation with you.
Yeah, and this person asked specifically because she missed the part on costs. I didn't cover it in very much detail here. It was just to say that it is allowed to charge reasonable costs, but that we still find that public authorities still charge very dissuasive costs, and that can be a ground for challenge. But we can go into more detail on that in a future webinar if that's something that you're interested in. So we were going to give you a kind of questionnaire to ask you what aspects would be interesting to go into in much more detail.
Mm-hmm. Yes, I mean, maybe also on this point, Anne has already mentioned that we have a particular some challenges in certain member states. We particularly have observed that ourselves now in Germany. There we've really been charged excessive costs for access to information, access to environmental information. And by some regional authorities. There's not really a consistent practice. And there is some case law of the court on this, but it is not very clear. But the court has said that costs shouldn't be dissuasive. They shouldn't be higher than exceed the individual financial capabilities and of the person requesting, and they should also in any event not be objectively unreasonable. So that's kind of the standard that one has to deal with there. But yeah, as Anne said, perhaps more in a future webinar on this.
We've had another question that's specifically on France. Maybe if you could email us directly, then we can put you in touch with someone in France that may be able to give you more specific advice on that. That would be no problem. That was from Claudette Daly. Our email addresses, are they on the screen?
No, they're not, but we can put them on the screen.
And then we can put you in touch with someone working on this in France.
There we are.
Thank you.
Waste and emissions.
Waste and emissions. That's a really interesting question. To my knowledge, at least on EU level, there's definitely no case law on waste and emissions. I'm not saying that there isn't, maybe somewhere at the member state level, but yeah, that would require some research. But if you, again, want to email us and we can consider maybe some arguments you can put forward, and that would really require us to know a little bit more what you're looking for as well. So please do get in touch.
Yes. I mean, as Anna said, there is some more recent case law from the court on what emissions are, so that might already be a starting point. But yes, please feel free to write to us too.
Right, so there's another question asking if we will provide a presentation on the notion of information on emissions. So that is certainly doable. So we'll maybe just put our poll on the screen just now so that you can tell us what you would find more interesting. That's definitely one of the options. Have you listed best practice in member states? No, we haven't. We haven't done that yet. To be honest, we haven't done extensive research on the practice in all of the member states, so we really wouldn't be in a position to do that at the moment.
Mm-hmm.
Right, shall we?
I mean, when you look for best practices, one thing to consider is so there's a task force under the Aarhus Convention that deals with access to information, and they do gather sometimes things like best practices, and they have there's a clearinghouse, an Aarhus clearinghouse. And perhaps include that in, if we send around the presentation, a link to that. But yeah, it's limited information on that, and it's a lot of it is not very accessible, but it might at least give you some indication, maybe.
Yeah, it's also worth pointing out as well that if you go onto our website, for the project, which is Sebastian, there is also a database of lawyers, including French lawyers, that work on these issues. So you can also get in touch directly with lawyers yourselves by using the resource which is on our website. Okay, should we put up the poll?
Yeah, you can put up the poll. I think. No questions now. Poll.
Yeah.
So we have first this poll. I hope you can all see that.
And then secondly, if you answer that, then you'll have options as to exactly what topics would be interesting.
Okay, so that's very, very clearly, I think people are in favor of that. Then let's start the second one directly. So these are some possible topics. So we've already heard that information on emissions might be interesting, but we've listed here also some other possible answers.
Sure.
Maybe this does. See? Oops.
Oh yeah, I've got it. Okay, yes, you should be seeing that on your screen. Okay.
Oh, this is quite equal.
And if there's any others, if there are any other aspects, then just write it in your comments section just now that aren't included there.
Yeah, like as a question, essentially. Okay. Oh, very equal.
Okay.
Okay, yeah, so we will for sure have 2 more webinars. And so we will then just have to see what we'll cover specifically. Yeah, also based on this poll, but that might.
Should we show the results?
Yes.
Okay. Okay. And yeah, as I said, let us know if there's anything that's not covered there you really want to hear more about.
Okay. Yeah, question and answers. We have some more.
So there's someone that's asked a question that, yes, I am very familiar with, and she asks, when you really need to access information to be able to participate in a decision-making process, but the decision-making process is moving quite fast, so there's a chance that it could be, finished quite soon. Do we see public authorities using exceptions just to basically buy them time so that we don't get access to the information before the end of the decision-making process? Oh, well, we have our opinions on that. It's true that, we have our opinions on it. In some cases, we suspect that's the case. But it is a very problematic thing because the timelines, at the EU level, it's 15 working days, which is essentially 3 weeks. And the deadline can be extended by a further 15 working days. So that can be 6 weeks before you hear back from them, and that can be a real problem in having access to the information in a timely manner, or at least in time to be able to use it strategically. So we have, that's really where active dissemination becomes very, very important, and pushing public authorities on their obligations to actively disseminate information, and to try to push also enforcement of that obligation, which just now is really lacking at the moment. So yeah, it is a problematic thing. Absolutely.
Yeah, I think another factor is just that in an ideal scenario, review procedures would just take a very short amount of time. This is, I think, it's clearly envisaged by the IS Convention that you should have access to information, particular timely resolution of your request. So I think there's certain movements like information commissioners and so on that are perhaps able to reply relatively quickly, but then often they get overloaded too, and then they don't have the adequate staff to reply in a short time period. So this is really a big problem. There's been some findings on this of the IS Convention Compliance Committee too, that said that this is insufficient. One in particular now against Norway, C93, and we've at one point attempted to make a symbolic damage claim for this. It was in my old job in front of the Court of Justice. So we've asked them, because of the delay, that essentially the commissions stopped replying to us, and then just disclosed the information once we were in front of the court, and it had become irrelevant because that was a year and a half later. That they should order kind of a symbolic amount of damage because of this undermining the rights that we were relying on and so on. But the court didn't go along with our argumentation on that point. So there's not much you can do except change the institutions, and as Anne very rightly said, have more active dissemination. All right, shall we?
So,
I think there's right now no more questions. So I think maybe some more things to mention. On the one hand, as you see right now on the slides, we have prepared a number of documents as part of this project that you can refer to, not only with regard to environment information, but actually, in fact, mostly with regard to access to justice. There's a guide We have a database on our website of lawyers from different member states. This might also be, there's also some French lawyers there. So for the person that asked on that assistant, that might be relevant. But there's also lawyers from Germany, from Austria, Estonia, Spain, Hungary, and I'm for sure forgetting some other countries right now. Slovakia is also one. And we will have 2 more webinars on exit information. The dates for those are not set yet, but there is one webinar that is coming up, and that is on challenging activities that harm the environment. That is also on the slide right now. It relates to the it relates to Article 9.2 of the RS Convention and the
EIA Directive and the Habitats Directive.
Okay, so I think that's it from us today. So if there's no other questions, we'll just close the webinar here. Thank you all very much for participating. And I hope that we can welcome you soon at one of our future webinars or at another event organized by ClientEarth.
Thank you. Bye-bye.